My name is Wolf, and this is a note from the probability field. We need to talk seriously about the U.S. Supreme Court. In light of some of the recent rulings issued by the court, we need to consider if a bunch of people who just seem to have gotten out of a clown car and are treating the Constitution like it's some kind of balloon animal that they can twist into any shape they want, we need to consider if these are the right people to be sitting on the highest court in the land. The Constitution, per Article 3, Section 1, states in part, "Judges, both of the Supreme and inferior courts, shall hold their offices during good behavior." And Section 2, in part, reads, "The judicial power shall extend to all cases in law and equity arising under the Constitution." The good behavior wording has been taken to imply a lifetime appointment to a pretty awesome responsibility, or at least until they resign or retire or are impeached, and they can be impeached. Given that the Constitution contains no stated qualifications or criteria for federal judges, that's including the Supreme Court, which right now is supremely out of sync with a large majority of Americans, it seems incumbent upon us, because of that situation, that we, the people, need to evaluate whomever the slate of justices may be to assure that they are capable of and deliver unbiased, fair, and equitable rulings based on an honest and full culturally contextual understanding and interpretation of the Constitution. If we do find this is not true for any sitting justice, then we can take steps to remove and replace them. We do this per Article 2, Section 4 of the Constitution, which states in part, "All civil officers of the United States," and judges are civil officers, "shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." By the way, high in this sense does not mean a majorly egregious offense. It means they are held to a higher standard. So qualifying offenses need to meet a lower threshold than usual to be considered a crime warranting impeachment. Under Article 1 of the Constitution, the House of Representatives can impeach a justice by a simple majority vote. Then, of course, a two-thirds majority vote in the Senate is required for conviction. There have been 66 federal judges, including Supreme Court judges, investigated for impeachment. 15 of them were impeached, 8 were convicted, 3 resigned to not face impeachment, and 4 were acquitted. Some of the reasons for those convictions: abuse of power, perjury, sexual assault, making false or misleading statements, improper business relationships, and mental instability. Other possibilities we have for moderating the court are to set rules requiring a supermajority for decisions. For example, requiring 7 of the 9 justices to overturn or change a ruling. We could also expand the number of justices on the Supreme Court. Originally, there were 6 justices, and a while back it was increased to 9 to be in sync with the number of judicial circuits. Now there are 13 circuits, so there's a precedent to update the number of justices again. Also, the president can reassign a judge. A federal judge has a lifetime appointment, but the Constitution only states that it be to a federal court, not necessarily the Supreme Court. Okay, let's look at 3 of the more controversial rulings from this term and see what we can learn about the current members of the court. We'll look at the concealed carry case from New York State, the Maine schools decision, and the Mississippi Gestational Act case. The concealed carry case is New York State Rifle and Pistol Association versus the superintendent of New York State Police. In New York State, there's a license required to possess a firearm. An individual who wants to carry a firearm outside the home may obtain an unrestricted license to have and carry a concealed pistol or revolver if they can prove that, and I quote, proper cause exists for doing so. Two people who did not meet the concealed carry requirements were denied permits, so they sued the state for violating their Second and 14th Amendment rights. The New York District Court dismissed the complaint, and that decision was affirmed by the Court of Appeals. But the conservative majority of the Supreme Court has overturned the New York State ruling. It held that New York's proper cause requirement, and I quote, violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. What exactly are ordinary self-defense needs? They don't explain that. The ruling states, to justify firearm regulation, the government must demonstrate the regulation is consistent with the nation's historical tradition of firearm regulation. That's a quote. In doing this, they argue against the Heller case from 2012, where the court set out 3 levels of scrutiny for gun regulations: strict scrutiny, intermediate scrutiny, and rational basis. Following this structure from Heller, the circuit courts upheld the regulations, including prohibition of weapons on government property, that a ban on juvenile possession of a handgun does not violate the Second Amendment, and actually the very New York law regarding concealed carry in public, now at issue, they ruled that it did not violate the Second Amendment. The current court's argument in overturning that ruling goes on about how difficult historical analysis is, and that a historically fixed meaning of the Second Amendment does not apply to just 18th century weapons. They then go on citing historical precedent to support their arguments. They also mention about how modern regulation is analogous to historical, though the magnitude of difference between historical and modern weapons and culture raises some questions about just how analogous they could be. They also argue that crowded, that's a quote, New York City is just not a sensitive enough place to require regulation, though the petitioners do not even live in New York City. The court then dismissed New York State's presentation of firearms regulation history from 1200 to 1900s to support their position, even though the court used historical precedents themselves. They did it by saying not all history is created equal. Because the court majority, taking an originalist view, felt, and I quote, constitutional rights are enshrined with the scope they were understood to have when the people adopted them. That means that since the Second Amendment was adopted in 1791 and the 14th in 1868, that is the only time frame to be referenced for interpreting the Constitution, unless, of course, you're the court. Also from the ruling, there is this statement: nothing in the Second Amendment draws a home public distinction with respect to the right to keep and bear arms, and the definition of bear naturally encompasses public carry. Well, you might not be surprised to hear that I disagree with this ruling, but before touching on a few specific reasons why I disagree, I want to address the underlying issue of the originalist style interpretation of the wording of the Constitution. I mention this because most, if not all, of the conservative majority on the court draw on this theory to underpin their arguments. Originalists believe the words of the constitutional text should be given the original public meanings they had at the time it was written and or became law. The meaning exists independently of the intentions or of the original expected applications of those who wrote the text. Seems a bit antithetical to what the founders had in mind. The originalist view of the meaning of the Constitution is limiting and very subjective. Discerning and applying the meaning of words as used in the 18th century compared to now does not account for the evolutionary or technical changes across all aspects of life that affect our human, cultural, societal, and planetary context. In regard to this case and also the next two, I think I can fairly say about all three rulings, the originalist interpretation of the Constitution seems wrong-headed, limiting, and appears to be used manipulatively to align with personal right-leaning conservative and sometimes religious values and views of some of the justices. I find their reasoning biased, weak, subjective, with supporting evidence narrowly selected and not fully representative of the issues. In particular, for the concealed carry case, as is stated, nothing in the Second Amendment text draws a home public distinction with respect to the right to keep and bear arms, and the definition of bear naturally encompasses public carry. So, the word bear. The definition of bear in this case includes to be equipped with something and to move while holding up and supporting something, but no part of any of the several definitions of the word use or imply the word public. So they just made that part up. Also, the Second Amendment does draw a home public distinction by its leading statement, and I quote, "A well-regulated militia being necessary to the security of a free state," referencing both regulation and public in the militia and the state. Plus, the 10th Amendment backs up the state's right to reasonably regulate, in this case, the carrying of handguns. The regulation by New York State does not impugn the petitioner's Second Amendment rights to keep and bear arms, nor does this regulation deprive them of any 14th Amendment rights of life, liberty, or property, and is not in any way harmful by increasing safety of the greater public community. A dissenting opinion was authored by Justice Breyer, with Justices Sotomayor and Kagan signing on. One more comment about the originalist interpretation of the wording of the Constitution. It seems to primarily be a way of twisting or adjusting the meaning of words to fit personal ideology. Here's what a couple of the founders had to say about interpreting the Constitution. And I quote, "On every question of construction, carrying ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debates, and not instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed." That was Thomas Jefferson. And Chief Justice John Marshall, a strong advocate for the ratification of the Constitution and the fourth Chief Justice of the Supreme Court from 1801 to 1835, he said, "We must never forget it is a Constitution we are expounding. It is intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs." Doesn't sound to me like it fits the originalist idea of interpreting the Constitution. The framers of the Constitution were visionaries, even as they addressed the challenges of bringing into being a new nation built on the ideas of fairness, equity, and guaranteed freedoms for all people, guided by the due process and rule of law. They were fully aware that they were communicating to the future. The Constitution lays out fundamental freedoms in general terms that are not self-defining. Along with a balanced and layered governmental framework, the framers knew the world would change. They trusted that on the foundation of spacious but sound principles and ethical processes, that the generations to follow, drawing on their own heart-centered intelligence, experience, intellect of mind and judgment, that they would continue development and developing and defining, giving meaning to those principles through time. I quote from an essay on Jeffrey Stone and William P. Marshall. The Constitution sets forth broad principles, and the central challenge of constitutional interpretation is to define and give life and substance to those principles in an ever-changing society. The principles enshrined in the Constitution do not change over time, but the application of those principles must evolve as society changes and experience informs our understanding. Moving on, next we look at Carson versus Macon in regard to the State of Maine Public School Tuition Assistance Program. The basics are, Maine is a very rural state with areas of population too low to support having a brick-and-mortar state public secondary school in all districts. So in order to provide parents with a free public education for their children, Maine has enacted a program of tuition assistance for parents who live in school districts that neither operate a secondary school of their own or contract with a particular school in another district. Under the program, parents designate the secondary school they would like their child to attend, and the school district transmits payment to defray the tuition costs. Participating private schools must meet certain requirements to be eligible to receive tuition payments. They must be accredited by the New England Association of Schools and Colleges, the NEASC, or they have to have approval from the Maine Department of Education. They otherwise differ from Maine public schools in various ways, but they must be non-sectarian, not associated with a particular religious denomination. The people bringing suit in this case sought tuition assistance to send their children to Bangor Christian Schools and Temple Academy. The schools are NEASC accredited, but they do not meet the non-sectarian requirement, and so they are ineligible for the program, and the tuition applications were denied by the state. The petitioners sued the Commissioner of Maine Department of Education, alleging that the non-sectarian requirement violated the Free Exercise Clause and the Establishment Clause of the First Amendment, as well as the Equal Protection Clause of the 14th Amendment. The district court rejected the petitioner's constitutional claims and granted judgment to the commissioner. The First Circuit Appeals Court affirmed that decision. After a lot of rambling around and actually agreeing to arguments in the previous case law that says, given that teaching the tenets of and promoting their faith is an integrated part of a sectarian school's curriculum, it is not about barring schools from receiving government funds based on their religious identity, but instead based on the religious use that they would make of funding in instructing children. Still, the conservative majority went against that precedent and ruled that Maine's non-sectarian requirement for tuition assistance payments, quote, violates the Free Exercise Clause of the First Amendment. The judgment of the Court of Appeals is reversed. Justice Roberts wrote the opinion, and the other 5 conservative justices affirmed. Justice Breyer wrote the dissenting opinion, joined by Justice Kagan and also Justice Sotomayor joining, except for Part 1B. Needless to say, I agree with the dissenters. It's obvious, even to those who reversed the Court of Appeals ruling, the First Amendment states unequivocally, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The main requirement does not in any way interfere with the petitioner's choice or free exercise of their religion per the Second Free Exercise Clause. But the First or Establishment Clause, which sets the standard for separation of church and state, clearly supports the main regulation in an effort to maintain that separation. By refraining from government sponsorship, financial support, or active involvement in any religious activity. I view this as a complete and purposeful violation by the court of its duty to uphold the Constitution in a frame of very personal political religious bias by the conservative majority. The third and last case we will evaluate is the Dobbs State Health Officer of the Mississippi Department of Health versus Jackson Women's Health Organization. This is the Mississippi 15-week abortion ban challenge to Roe versus Wade that has allowed the court to rescind a woman's constitutional right to control her own reproductive health care. And I quote, "The court holds the Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives." Well, I wouldn't say it was returned to the people at this point. We are not going to go through all the nearly 300 pages of this ruling, but I will hit a couple of points that support the contention that some justices of the court are using flawed and inappropriate methodology of constitutional interpretation that amplifies personal bias and lack of judicial neutrality. From the ruling syllabus, we have Roe held that the abortion right is part of a right to privacy that springs from the First, Fourth, Fifth, Ninth, and 14th Amendments. The Casey court grounded its decision to uphold Roe on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's Due Process Clause. The conservative court majority does not support this reasoning, saying, and I quote, "The Constitution makes no express reference to a right to obtain an abortion. And in interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy." That second statement sounds a little ominous, and I think it is the conservative justices who are confused. First off, we know the Ninth Amendment states, as referenced by Roe, and I quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Not stated does not mean that it is not a right." And I think we can see with the Fourth and 14th Amendments, the right to abortion or any personal medical care is incorporated. The Fourth Amendment states, in part, "The right of the people to be secure in their persons, houses, etc., against unreasonable search and seizures shall not be violated," and goes on from there. The word persons means a living being, a living body of a human. That is the definition of the word. The 14th Amendment reads in part, "All persons born or naturalized in the United States are citizens of the United States, and no state shall make or abridge privileges or immunities of citizens, nor deprive any person of life, liberty, or property," etc. The definition of life is the condition that distinguishes from inorganic objects and dead organisms, being manifested by growth through metabolism, reproduction, and the power of adaptation to environment through changes originating internally. The definition of liberty, the state of being free, the power of choice, the right to engage in certain actions without control or interference by government, free from physical restraint. It seems that according to what is written in the Constitution, it is not a stretch to conclude it grants a person the right to be secure, have privacy for their own body, and no government or state should abridge the rights of life, being the power of adaptation through internal changes or liberty, the power of choice, without control or interference by the government. According to what is written in the Constitution, it is not a stretch to conclude it grants a person the right to be secure, have privacy for their own body, and that no government should abridge the rights of life, that being the power of reproduction and the adaptation through internal changes, or liberty, the power of choice, without control or interference by the government. I think this clearly extends to a person's right to make their own decisions, personal medical decisions, for the health of their own body with their doctor without any interference from state or federal courts or government. Obviously, this includes a woman's reproductive health care. Also from the brief, point number 2, the quality of reasoning. Without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy divided into trimesters, much like those found in a statute or regulation. Have these justices never had children? The first documented use of the word trimester was in 1821, and in obstetric care, in regard to pregnancy, it was in 1900. Since then, it has obviously become the standard way of demarcating the stages of pregnancy. Roe did not impose a set of rules for trimesters on anyone. From 1900 on, it evolved as a term of art in the medical field, being shorthand reference for common knowledge of the stages when various developments and changes of pregnancy take place. It is well documented that midwives were very aware of the stages of pregnancy prior to the use of the word trimester by tracking the changes in the body and metabolism of the pregnant woman. And that is the set of rules the court refers to that became codified in reference to a particular trimester. The last statement we'll look at is, and I quote, Roe's failure to even note the overwhelming consensus of state laws in effect in 1868, meaning laws against abortion. The court finds that the right to abortion is not deeply rooted in the nation's history or tradition. End quote. This is pretty much BS. While it's true that in 1868 some states had abortion laws, anti-abortion laws, that is a very narrow, misleading statement, once again demonstrating the inadequacy of the Originalist approach of interpreting the Constitution. Actually, from the 1600s to the early 1800s, abortion was completely legal in the United States. Medical literature and newspapers in the 1700s and early 1800s regularly referred to herbs and medications as abortion-inducing methods. And a book published in 1748 by Benjamin Franklin, contributor to and signer of the Constitution, contained herbal recipes for controlling and ending pregnancies. After the colonies became states, there were some restrictions on abortions that occurred after quickening, around 18 to 20 weeks. But they were rarely enforced, and significant documentation shows there were no laws against abortion till one in Connecticut in 1821, and an additional handful of others till just prior to the Civil War. Prior to the Civil War, very few men were involved in obstetric or gynecological care. It was an area of medicine almost entirely handled by midwives, who also covered many other aspects of rural community health care. But in 1847, the AMA was founded, and a mostly economics-driven movement to prevent midwives from providing prenatal care and birthing services began. In 1855, Harvard Med School grad and European-trained Horatio Storer began a practice in Boston, focusing on obstetrics and gynecology. He joined the AMA in 1856. Storer stated, and I quote, "He believed that abortions endangered the ideal America, a society of white Protestants in which women adhered to their proper duties, marriage and childbearing, and that abortion was morally wrong." So, in 1857, he began the Physicians' Crusade against abortion, and he persuaded the AMA to create the Committee on Criminal Abortion. The AMA then petitioned U.S. state and territory legislatures to strengthen their laws against elective abortions. Their lobbying met some success. By the time the 14th Amendment was ratified in 1868, 24 of the then 33 states had anti-abortion statutes. If you look at those early anti-abortion statutes, and the conservative majority has listed them in the appendix of the ruling supporting their filtered view of history, you will see that all of the laws use nearly identical wording, taken almost verbatim from the AMA proposed statute. So, we have the weight of over 175 years of precedent when abortion was legal and practiced in the colonies, turned United States, weighed against about 11 years of an organized campaign of racist and religiously biased lobbying to make abortion illegal when the 14th Amendment was ratified. And that is what the conservative majority of the court is using to underpin their partisan view that Roe was wrongly decided in the first place. That is constitutionally BS. The justices are trying to carve abortion and contraception out of reproductive health care and make them standalone criminal issues based on their personal, religious, and ideological biases, not science. The AMA and ACOG, the American College of Obstetricians and Gynecologists, who know a whole lot more about it than the Supreme Court, both declare reproductive health care, including contraception and abortion, a human right. One more thing in regard to abortion rights. The 14th Amendment articulates unambiguously all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside, and no state shall abridge the privileges or immunities of citizens of the U.S., nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws. There is no mention or reference of any kind in regard to preborn or unborn persons. Given its explicit wording, the Constitution and the rights guaranteed thereby do not apply to a fetus until it comes to full term, is born, and becomes a person separate from and independent of the mother. End of story. Okay, returning to what I said at the beginning. It is incumbent upon us, we the people, to evaluate whomever the current slate of justices may be, to assure that they are capable of and delivering unbiased, fair, and equitable rulings based on an honest and full culturally contextual understanding and interpretation of the Constitution. I think even from this brief review of just these three rulings, there's much to consider. We can already see that there's the emergence of patterns in this ultra-conservative court's approach to cases. You will have to come to your own conclusions, but here's what I think. Number one, we have allowed a bunch of racist Christian nationalists to dominate the Supreme Court. They obviously have no regard or respect for the Constitution or the rights it guarantees to everyone. They are actively trying to dismantle our democratic republic and should be removed from the bench as soon as possible. In particular, I am talking about Justices Roberts, Gorsuch, Alito, Thomas, Kavanaugh, and Barrett. Number two, they have demonstrated an inability to evaluate evidence with judicial neutrality. Number 3, they have shown political and religious bias. Number 4, they have misrepresented, ignored, and possibly suppressed relevant evidence. Number 5, they have violated their own sworn duty to uphold the laws and spirit of the Constitution. Number 6, Justice Thomas should step down or be removed immediately due to an irreconcilable conflict of interest, as his spouse is an extreme right-wing activist with involvement in the June 6, 2021 insurrection. Number 7, allegations of possible perjury by justices during confirmation interviews need to be investigated. So here's a reminder of what can be done. Impeachment, top of the list, we can do that. Number 2, set rules requiring a supermajority of justices to make decisions. 7 of 9 at this point. Number 3, expand the number of justices on the Supreme Court to equal the number of federal circuit courts. And the president can reassign judges. For myself, I think the bad behavior threshold has been reached and breached, and the impeachment proceedings and investigations of Justices Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett should begin ASAP. Also, and I don't know if this is possible or what it would take to accomplish, but I think all flawed rulings should be vacated. All the rulings made by this court that are flawed, vacated. And I think all 3 of the rulings we looked at here and reviewed fall into that category. So I think we'll leave it there. Don't forget to speak up and speak out. Contact your congresspeople, write them, call them, contact the White House, write Joe, call Joe, let them know what you think, what you feel. And vote. Vote, vote, vote. Thank you. We'll talk again.